This is the fourth of 5 short talks I gave at the Symposium on Financial Crime held at Jessus College Cambridge in late August 2026. Pursuing crypto assets in the civil law. I will begin with a question that appears almost absurd. When a court orders the recovery of cryptocurrency, what exactly is it recovering? The obvious answer is property. After all, civil law is built upon property, ownership, possession, transfer, restitution, and recovery. That is what lawyers do. Or so they believe. Today I want to suggest that civil asset recovery is not about recovering property. It is about recovering power. And once you understand that, crypto stops being a technological curiosity and becomes a constitutional crisis. There is a dangerous illusion at the heart of modern civil law that it is protecting property. It isn't. It is defending an 18th century theory of power against a 21st century technology. Crypto has simply exposed the illusion. Ownership, fraud, debt, trust, contract. The language has hardly changed in 2,000 years. But what about Bitcoin? Hiding behind multi-signature wallets, decentralized exchanges, smart contracts, and privacy protocols. That should worry us. Although the problem is not cryptocurrency, it is the law itself. The legal profession is asking the wrong question. Who owns the asset? Which belongs to the industrial age. They should ask, who controls the network? Power has migrated from land to factories, to corporations, to information, and now to algorithms. Yet civil law still behaves as though ownership remains the organizing power of society. It doesn't. Control does. People are taught that property is a natural right. It isn't. Property is a government-sanctioned monopoly right, which they can confiscate at will. Society grants one individual the exclusive right to control something, while excluding everyone else. That monopoly exists only because governments enforce it. Remove the courts, the police, the state, and ownership becomes mere possession. Property is not a law of nature. It is a political technology, one of humanity's greatest inventions. And that raises an uncomfortable question. If exclusive control can be created through cryptography rather than legislation, who grants the monopoly? The state or the protocol? That question takes us far beyond Bitcoin, into the very foundations of civilization. Now, in the technological construction of reality, Dionysius Demetrius and I argued that technology does not merely support society, it constructs the reality within which society operates. Blockchain technology is constructing an alternative reality, not merely a new payment system, not merely a new asset class, an alternative mechanism for establishing trust, authority, identity, ownership, and yes, even sovereignty. Today, the courtroom increasingly operates inside realities designed not by legislators, but by software engineers. Years ago, in the book The New Barbarian Manifesto, I argued that power was escaping geography. The wealthy no longer needed kingdoms or armies or even countries. Capital simply moved elsewhere with the new barbarians. Cryptocurrency represents the next stage. Capital itself has become nomadic. The barbarian renders borders irrelevant. People often tell me that blockchain changes everything. I disagree. Blockchain changes nothing. It merely reveals what was always true. Money has never really been about coins. Property has never really been about objects. Law has never really been about justice. They have always been systems for organizing power. Crypto simply strips away the camouflage. This is the argument that Dionysius and I explored in Science's First Mistake. We humans repeatedly confuse our descriptions of reality with reality itself. Property is one such description. Ownership is another. Corporations, money, contracts, states, they are all extraordinary useful social constructions. But they remain constructions. Crypto has produced a rival construction, and suddenly the old ones no longer look inevitable. Now consider what happens in a successful crypto recovery. Nothing physical moves, no vault is open, no gold is seized, no warehouse is emptied. Instead, control over cryptographic permissions changes. That is all. Not property, but permission. Not ownership, but authority. Not assets, just power. The courts are not recovering objects, they are reallocating control. That is why I object when authorities proudly announce they have recovered millions of pounds of cryptocurrency. Recovered from whom? Recovered where? Recovered how? What they have really done is something far more significant, actually. They have reasserted the state's monopoly over monopoly itself. Civil recovery has become a struggle between two competing systems for granting exclusive control. Government or mathematics. And this is the only beginning. Artificial intelligence will negotiate contracts. Automatic organizations will own billions. Machine agents will trade continuously. Programmable entities will unlock programmable money. Smart contracts will execute without any human intervention. When two autonomous AIs enter into a transaction using assets held by a decentralized protocol, who exactly is the defendant? Which jurisdiction governs? Which property has been stolen? Who appears before the court? Such is tomorrow's litigation. Perhaps the greatest irony is that the lawyers believe they are adapting cryptocurrency to fit civil law. The opposite is happening. Crypto is redesigning civil law, not by changing legislation, but by changing the reality itself. And reality always wins. Let me leave you with one final uncomfortable question. If the future belongs not to those who own property, but to those who control digital reality, are civil courts still recovering assets, or are they deciding whether exclusive control in society will ultimately be granted by governments or by mathematics? Because that is the real battlefield. Not Bitcoin, not blockchain, not crypto. We are fighting over the very future of sovereignty itself. Thank you.